Attention all viewers. Did you know how easy it is to be granted workers' compensation in Queensland? Today, Steph and I are representing the employers of construction businesses within Queensland, and we have one striking issue to bring to the table. Employees are taking advantage of the system and practicing contributory negligence. They are able to do this so easily because our current system of workers' compensation law operates as a no-fault scheme. A no-fault workers' compensation scheme means that in Queensland, workers have the right to apply for statutory benefits no matter who or what caused their workplace injury. This almost guarantees that every claim submitted will be approved and compensated for. This presentation will provide a brief history of the workers' compensation law and how it applies today. A summary and critique of the state of law will be explored, supported by evidence and a critical analysis of all the shortcomings of the current law. These shortcomings will then be examined by observing the effect it has on employers within the workplace, and a brief reform will be given.
Although the complex system and idea of workers' compensation seems relatively modern, it actually dates back to the ancient Sumer, which is now known as modern-day Iraq. In 2050 BC, the ancient Sumerian law outlined compensation for injuries relating to a worker's specific body part. For example, the ancient Greek, Roman, Arab, and Chinese laws all provided a schedule detailed with precise monetary payments for the loss of a body part. All of the early compensation schemes consisted of these schedules, and specific injuries determined specific rewards. Their ancient distinctions between impairments and disabilities still inform our workers' compensation laws today. The development of the English common law in the Middle Ages and Renaissance provided a legal framework that persisted into the Industrial Revolution. This is where the unholy trinity of defenses was born and determined which injuries were compensatable under law. If the employer could prove that one of these defenses were true about the injury, there was no action. Contributory negligence was a 100% defense if the employer could prove that the worker was responsible for his own injury, regardless of how hazardous the environment or machinery was. The fellow servant rule, also known as the common employment defense, provided that if your injury was caused by a fellow co-worker, there was also no action available. And finally, a voluntary assumption of risk provided no action for injuries that occurred in dangerous workplace environments because the employee had contracted to undergo a job that produced several everyday dangers. These common law principles were very restrictive, extremely employer-friendly, and very costly for an employee to lodge a successful claim. Workers' compensation is nevertheless important because it protects employees from risking their health, safety, and assets for their job. The common law rules progressed over time and was eventually legislated into the Workers' Compensation and Rehabilitation Act in 2003, which is what governs all workers' compensation claims today.
Before we get into the nitty-gritty details, it is important that we outline who it is we will be referring to. The Workers' Compensation and Rehabilitation Act provides all of the relevant definitions that will be referred to for the remainder of the presentation. The Act defines a worker as a person who works under a contract and is a PAYG employee. An employer is classed as a person who engages a worker to perform work. An injury is described as a personal injury arising out of or in the course of employment, if the employment is a significant contributing factor to the injury. And finally, the most important thing to note is that a no-fault system provides that a worker is able to get compensated for their injury if they cannot prove fault, and more so even if it is their fault. Therefore, if the worker is the person who is being negligent, they are legally obliged to be compensated for their injuries.
On behalf of Queensland construction employers, we argue that due to the fact that Queensland has a no-fault compensatory scheme, it is apparent that employees are taking advantage of the simple procedural system and are practicing acts of contributory negligence. Because of this, the employees know that they will be entitled to compensatory damages, whether the validity of their claim is true or false.
Condi and State Transport Authority 1984, volume 154 of the Commonwealth Law Reports, at page 672, highlights that the employee-employer relationship is an established category, which places a non-delegable duty on the employer to take reasonable care of the employee. This duty is attached to the employer regardless of personal fault on their part, as long as the employee can prove that damage was caused by lack of reasonable care on the part of someone within the scope of the relevant duty of care. When discharging this duty, the employers must have regard for an employee's misjudgment, inadvertence, or inattention. In Queensland, the common law remains the primary regulation defining the duty of care owed by an employer. The case of Satrico and Edith Cowan University, 2005, volume 214 of the Australian Law Reports, at page 349, established that employers owe a duty to their employees to take reasonable care in the circumstances to avoid foreseeable injury to an employee. To satisfy that, an employer has a duty to provide a safe system of work, a safe place of work, and to provide proper plant and equipment. Interestingly, in cases involving psychiatric injury, Kohler and Cerebos Australia Limited, 2005, volume 222 of the Commonwealth Law Reports, at page 44, established that there is no duty of care owed by an employer to an employee if it is not reasonably foreseeable that the employee could suffer from psychiatric illness by carrying out the job that they had contracted to do. We refer to the definitions outlined in the Workers' Compensation and Rehabilitation Act concerning the following: standard, breach, causation, onus, contributory negligence, and obvious risks. Yet all of these definitions are supported by common law. According to Section 305B of the Act, the standard of care is described that a person does not breach a duty of care to take precautions against a risk of injury to the worker unless the risk was foreseeable and the person ought to have reasonably known that the risk was insignificant, and in the circumstances, a reasonable person in the position of that person would have taken the precautions. A foreseeable danger was defined in Wyong Shire Council and Shirt 1980, volume 146 of the Commonwealth Law Reports, at page 40, as one which a reasonable person in the employer's position would have foreseen as involving a risk of injury to the employee arising out of the employer's conduct. Under Section 305C of the Act, in proceedings relating to liability for a breach of duty, three things are considered. Firstly, the burden of taking precautions to avoid a risk of injury includes the burden of taking precautions to avoid a similar risk of injury for which the person may be responsible. Secondly, the fact that a risk of injury could have been avoided by doing something in a different way does not of itself give rise to or affect the liability on the employer for the way in which the thing was done. And thirdly, the subsequent taking of action that would have avoided the risk of injury does not of itself give rise to or affect liability in relation to the risk, and does not of itself constitute an admission of liability in connection with the risk. At common law, Green and Hanson Construction Materials, 2007, in the Queensland Court of Appeal, at page 60, established that an injured employee bears the onus of establishing a reasonably practical alternative system of work compared to the one prescribed by the employer. However, once it is established that an alternative system of work would have avoided the risk of injury, the employer can still escape liability if it was unreasonable to adopt this alternative system, so long as their reasoning does not involve referring to little difficulties or expense. Causation is the key element in all workers' compensation claims. Section 305D of the Act states that a decision that a breach of duty caused a particular injury comprises of factual causation and the scope of liability. This means that the breach of a duty was a necessary condition of the occurrence of the injury, and that it is appropriate for the scope of liability of the person in breach to extend to the injury so caused. At common law, an injured employee must establish that the employer's breach of duty was a material cause of the employee's injuries. The case of Nathan Cahill and Gregory Mark Bowden marks the importance of proving the causal link between the damage that was suffered and the alleged negligence of the defendant. This case reinforced that it is not enough to show that there was an act or omission by an employer and that there was also an injury. The specific act or omission must have caused or materially contributed to the injury for an action to be made. In any fact relevant to the issue of causation, Section 305E states that the worker must always bear the onus of proving, on the balance of probabilities, that there was a breach of duty that caused their injury. Primarily, it is imperative to note that a claimant's behaviour must exceed mere inattention, inadvertence, or misjudgment before it is considered to be a contributory negligent act. According to Section 305F of the Act, the standard of care required in contributory negligent cases is that of a reasonable person in the position of that person, and the matter is to be decided on the basis of what that person knew or ought to have reasonably known. Section 305H then provides a non-exhaustive list of some of the circumstances where the courts may make a finding of contributory negligence. In situations where the worker relevantly failed to comply with the instructions given by the employer for health and safety benefits, and failed at the material time to use protective clothing and equipment provided by the employer, in situations where the worker failed to use anything provided designed to reduce the risk of injury, or the worker inappropriately interfered or misused equipment, when the worker was adversely affected by the intentional consumption of a substance that induced impairment and undertook an activity involving an obvious risk and failed to take account of that obvious risk, and finally, where the worker failed without reasonable excuse to attend safety training sessions reasonably organised by the employer. In these aforementioned situations is where the courts may make a finding that contributory negligence was apparent. The meaning of an obvious risk is outlined in Section 305I as a risk that would have been obvious to the reasonable person and are patent or a matter of common knowledge. Obvious risks may have a low probability of occurring. They might not be prominent, conspicuous, or physically observable. Obvious risks, however, are not considered to be the result of a failure to properly maintain, operate, replace, prepare, or care for a thing, unless the failure itself is an obvious risk. Thankfully, Section 305G of the Act states that contributory negligence has the ability to defeat a claim by 100% if the court considers it to be just and equitable to do so. However, this is then contradicted by Section 305K, which then states that an application of contributory negligence for particular injuries states that despite any other provision of this division, treatment, care, and support damages are awarded to a worker who is entitled to compensation under Chapter 4A for the injury cannot be reduced for the worker's contributory negligence.
As set out in the Workers' Compensation and Rehabilitation Act, certain criteria must be met in order for an employee to lodge a compensation application. Corresponding procedures must be followed as well. It has been stated that the eligibility for workers' compensation hinges on 3 core criteria. 1. The claimant must fall within the category of worker covered by the statute. 2. The claimant must have suffered the type of injury or disease covered. And 3. The injury or disease suffered must be appropriately connected to the employment. There are 2 types of claims that may be made with Queensland Work Cover: a statutory claim and a common law claim. However, an employee can only seek damages for an injury using one route or another at a time. When lodging a statutory claim, in keeping with the no-fault scheme, Neither the employee or employer is found to be at fault for an employee's injury and is the type of claim that will be lodged with Queensland WorkCover. A brief highlight of the core sections of Part 5 in the compensation application and other procedures will be outlined. Section 131 deals with the timing of an application. It states that an application is valid and enforceable only if the application is lodged within 6 months after the entitlement of compensation may arise. As well, if the deadline to lodge a claim is missed by more than 20 days, then the liability that rests with an insurer to pay out can only be given to a maximum of 20 days from when the application was lodged. Section 132 outlines the procedure for applying for compensation. An employee must see a medical practitioner for their injury as soon as possible. The practitioner may be a dentist, doctor, or nurse who adheres to the workers' compensation certificate protocol. After an injury has been assessed, a workers' compensation medical certificate will be awarded